Morning, ladies and gentlemen. Welcome to Magic Bricks Hangout series. Our endeavor is to trigger a buy and bring back consumer confidence in the real estate market. The topic of today's session is Bangalore Realty, checking the legalities of your property before purchase. To discuss on the same, we have Vatsala Dhananjay. She's an advocate and founder at Vatsala Dhananjay and Company. Vatsala is a well-known lawyer having over 20 years of experience with local properties and Karnataka laws. She has been honorary advisor and has contributed extensively to the guidebook on buying, investing, and renting property in Bangalore. She is also a member of New York State Bar Association, that is the Foreign Lawyers section. I also welcome Namrata Eka. She is a senior journalist with Magic Bricks. Over to you, Namrata.
Hi, Vatsala. Welcome. Like I told you before, we have been getting a couple of queries from our consumers for the past 1 hour or half an hour, and we've selected some of the very good queries so that you could answer. So before wasting any time, let's begin. The first question is from Sujay from Mumbai, and he says, are the documents required while purchasing a new and resale property same? Or is there a difference in the list of documents that is required?
Yeah, basically for resale property, there is an additional link required. That is the link between the builder and the first owner of the property.
Okay.
Otherwise, all the properties are exactly the same. You just have to add on the new purchaser's sale deed and his revenue documents and property tax paid receipts and maintenance and encumbrance certificate up to date.
Okay, could you tell the consumers what a revenue document is? What does it cover? What details does it cover?
Yeah, the revenue document is basically reflecting the purchaser's ownership for purposes of property tax collection.
Okay.
So, as you get the sale deed registered, you'll have to submit it to the revenue department so that they can tax you. And this document is called as Khata in Bangalore and Patta in Tamil Nadu, and by different names. Basically, it's your reflecting your ownership in the revenue department for the purposes of collection of property tax.
Okay, all right. The second question is from Rashi, and she's from Gurgaon. She asks, my brother-in-law duped my father-in-law in signing the property in his name. Now he has sold it off to an outside party to pay off his loans. Can we take any legal recourse as my husband also had a right to the property?
Yes, this will come under the criminal case. It's basically a matter of cheating. Certainly she has to immediately file a police complaint. I hope she has not slept for a very long time. And she has also to file a suit for injunction restoring possession in her name. So there is a civil remedy and a criminal remedy, both of which are available to her.
So, are you saying that she has to, hire the services of a criminal lawyer for this particular case?
Yes. First, she has to file an FIR for cheating.
Yeah.
She also has to, if the police say no, this is a civil case. Sometimes they take that attitude. This is a civil case, and you are claiming forgery and all those things. So it is better to file uh, civil suit also along with the FIR. The FIR can allege forgery. The FIR can allege cheating, and you can also back it up with a civil suit for restoring possession to you.
And how long do these cases go on approximately? I know each case is very different from each other.
Yeah,
But
no, I'd rather not comment on this. The criminal case may be much faster than the civil.
right. Oh, okay. So the third question is from West Bengal. The consumer's name is John. He says, there is a piece of land behind my property which I was to invest in, as it would add value by expanding the property size.
Your voice is breaking. Your voice is breaking.
Can you hear me now?
Yeah.
Okay. Should I repeat?
Yeah, please.
So, John from West Bengal says, there is a piece of land behind my property which I was keen to invest in, as it would add value by expanding my property size. I have been living on the land for 7 years now. As per her, the owner of the land should ask me first before selling it off. Now that someone bought it. I'm contesting. Is there any hope of me winning the suit, or is it a lost cause?
Okay, see, from what I can understand, this piece of land abuts his property, and the entrance is through that piece of land. Am I right?
Right.
Okay. Yeah. So he was supposed to have a preemptive right of purchase. Preemptive right of purchase means a right to have the first offer to buy that land. Now, preemptive right of purchase is always given for people who are co-owners of a property. Let's say I and my brother have an undivided or half share of an inherited property, and I want to sell my share. So the preemptive right of purchase should be given to my brother first. Okay. In this case, there is no relationship or there is no co-ownership of that piece of property. He is just a neighbor who is also happening to be in front of him.
Right.
As long as the right of way exists for this person who has asked the query, then there is no requirement that the front owner should offer him the first right of sale. So the presumption of the questioner is that he has a right to purchase the property. That I would need more facts to comment upon that. If on the face of it, prima facie, if such a right does not exist, then I don't think he should waste his time questioning that sale already made by the original owner to the present owner.
Right. So the owner has the liberty to choose his buyer, his party.
Yeah, yeah. Your voice is breaking again. Sorry.
Okay. Is it clear now?
Yeah, yeah. Can you speak a little slowly?
Okay. Um, the next question from Runima from Chennai. She asks, what kind of information can I expect from legal experts when asked to provide a legal opinion while buying a house? Can I expect everything in writing? If the lawyers say no issues, and if it later we find any legal issues, will the lawyer take the responsibility and compensate the financial loss? If
Okay, yeah, this is a very good question, and I keep getting asked all the time. See, in India, we don't have a sovereign guarantee of title, and we also don't have title insurance, wherein we can pay a premium and cover all the risks. So the best you can do is go to a competent lawyer. Now, even the best of lawyers will have a waiver clause in their title written title opinion, wherein they do say that they have based their opinions on the documents furnished to them, and they have conducted a due diligence in the sub registrar office for encumbrances on the property. The problem is many of these encumbrances are not reflected in the encumbrance certificate because agreements of sale are not required to be registered. So there may be all kinds of transactions which don't get reflected in the EC. Therefore, the title opinion can always be combined with a constructive notice on the property or a public notice in the newspapers prior to purchase. These are the things, and even local inquiries are very powerful. So these are the things that allow you to have a comprehensive title clearance, which is at best 95% accurate. You cannot expect 100% accuracy.
okay, okay. The next question is from Chennai. Jay asks this question. He says, I'm close to buying a property from the relative of a deceased lawyer. Since the lawyer did not have a successor, the property went to closing sale. But now I'm hearing that the lawyer has a son who works outside India. Is there any way I can make sure how many legal heirs are there and who they are? Any government record or any authentic document? What are the steps for verifying the legal heir?
Yeah, this is also a very good question. Now, the family tree is a very tricky thing because only the people in the family have knowledge of the family members.
Right.
So, we normally get hold of something called a family tree. Now, if the family tree is not truthful and there are some legal heirs who have been left out, uh, we nowadays, at least in Bangalore, there is something called a computerized family tree, which is given on an application by the Tahsildar. So he does go and verify with the neighbors before putting his seal on that family tree. That's a very lengthy process, and it has been recently introduced only because the family trees have been notoriously difficult to find out who they are. The second, the second thing way you can go about it is to get something called a legal heir certificate, which is again given by the revenue authorities only after verification, and it is also accompanied by a sworn affidavit that these are the true family members and that they are not lying. And if they uh, do not reveal all the family members, then it amounts to we can file a criminal case against these people for falsely swearing to incorrect facts. But I would always advise that local enquiries are very important to, especially when builders are constructing apartments. They can afford the time, and the due diligence has to be done to ascertain the family tree. Family tree is always, you must be suspicious of family trees if it's showing only sons, because if there are enough daughters, then you can make out that the family tree is a genuine one.
Okay. So in this case, Venki, he's in Chennai, and he says that the air, if there is any air, is outside India. So what should I mean, the sun does not come back if I contest for the property.
No,
So
no, then that sale will be illegal. He has to get the son into the sale deed, either through in person or through power of attorney from the US.
so you would advise Venki to get in touch, find out about the son and get in touch with him.
Yes, certainly. Otherwise, the sale of the property will be illegal unless the deceased lawyer has left a will in favor of this person from whom he is planning to buy.
Right, right. Okay, Nita, she says, I had cancelled with one of the builders in Mumbai. For cancellation, he has issued 3 post-dated checks of 2 lakh each within a gap of months. I will be depositing Pune. I'm afraid the first check, which is due in February this year, might get bounced. What legal options do I have if it does happen?
Yeah, see, check bouncing cases, as soon as she has to deposit it, and if it gets bounced for want of insufficient funds, then she has to file a criminal case within 15 days uh, of the check bouncing. Thereafter, the law will take its course. So she cannot anticipate that the check will bounce and be worried. It has to bounce, and it has to bounce for reasons of insufficient funds. As soon as that happens, she can move the court.
Right. So the first check bounces and she takes the legal.
Yeah. Yeah.
Okay. Rushi Mumbai asked, what is the documentation process and legality regarding buying an auction flat?
Okay, auction flats. See, there are 2 or 3 types of auctions. One is an auction pursuant to a default of a loan from a financial institution. The second is an auction by government authorities, say on corner plots or things like that. Uh, See, the first case where there is a default, and if the bank is selling it, you have to be more careful, because the person who has lost his right may agitate in court later on. It is a headache property basically. But if you are buying, let's say, a government property, like in Bangalore we have corner sites from the Bangalore Development Authority, which is always comes up for auction. Those properties are fairly clean in title, and all you have to do is they'll give out a tender in the newspapers. You'll have to reply to that. You'll have to deposit some minimum amount, and thereafter you'll have to participate in the bidding process. And if you are the highest bidder and your bidding is successful, you have to deposit the money with the concerned person authority, and they will issue you an auction sale deed and a katha. It is as simple as that. But the first type where the default happens, I would be more cautious about it.
Okay. Kotik from Bangalore says, I am looking for a flat in South Bangalore in the budget of 45 to 55 lakh, and there are numerous flats in this budget, but most of them are B khata. And if there are A khata flats, there is no occupational certificate. My question is, how do I find a partner to build a khata and also has an occupational certificate? How important is OC, occupational certificate, when moving to a flat in Bangalore?
Yeah, see, B khatas are normally issued when there is deviation from sanction plan. That is why they are not getting the occupational certificate, because it's above and beyond the permitted level of deviation. So
Okay.
now the second reason why B khata is issued is because there is some betterment charges which are required to be paid and which have not yet been collected from by the government from the builder. So because of that also B khata gets issued. The third type of B khata is issued when the property is not approved properly, like a panchayat plan sanction or a revenue site. So if it is betterment charges, you would probably consider buying it because it's a matter of just paying that money to the government later on. But if it is a lot of deviation above the permitted limits, then it is a little tricky to buy it. Nowadays, there is an Akrama Sakrama scheme which is supposed to come, which will regularize 50% of the deviation, but that is not yet out. It is still in High Court. It is sub judice. So, how the second part of the question is, how do you buy a property with a kata?
Which has an
Yeah, you just when you're going to lease your property, you can ask for whether it's a kata and whether it has an OC. I'm seeing a lot of properties nowadays with an OC certificate.
Just to take a step back, could you just explain to the consumers, potential buyers who don't know what an occupational certificate is?
Yeah.
In very basic 1 or 2 lines, if you could explain.
Right. OC is the occupation certificate wherein after the building is built, the concerned government authority which has sanctioned the plan will go and measure the building and see whether it is compliant with the sanction plan or whether it has been built more than that, whether there's any extra floor, whether there is a setback violation. And if they find that it is largely compliant within 5% of the original sanction plan, then the OC occupation certificate is issued. That means
Vatsala, can you hear me?
yeah, yeah.
Can we take the next question? This is from Surat Shetty from Bangalore. He says, I'm approaching SBI for home loan. My property has been legally verified and valuation has been done. This was required by the State Bank of India. Should I collect the same from the lawyers or the builder will be providing me with the documents for the loan?
Sorry. Can you repeat that question?
Can you hear me now?
Yeah, yeah.
Okay. Surat Shetty from Bangalore asks, I'm approaching State Bank of India for home loan. My property has been legally verified and the valuation has been done. Should I collect the same from the lawyers or the builder will be providing me these documents for loan? The documents related to legal verification and the valuation of the property.
Okay. See, the valuation of the property will be done by the bank. That will tell you what is the value of the property. The legal documents will definitely be given by the builder. Thereafter, the bank's internal lawyer will also issue his or her own legal verification, and that will be enough for him to get the loan.
Okay. Um, Veera Raghavan asks, what is the difference between a commercial property and a residential property in terms of legal formality and taxation?
Okay, commercial properties should have plan sanction for commercial use. It should also be compliant with zonal use, which are meant only for commercial use. You cannot put up a commercial property in a residential area if the zonal use does not permit it. Apart from that, the taxation angle of it is that you'll have higher property tax, you'll have higher electricity charges and higher water charges. Uh, there is no other difference as far as the land title is concerned. It's only at the last stage, if it is compliant with zonal use, that the sanction plan will reflect whether it is residential or commercial, and the tax will be a little bit more. Apart from that, there is no real difference.
Okay. Um, Varun Kapoor says, I'm going to sign a joint development agreement with a local builder. What specifications should I check before signing?
Yeah, you have to get the joint development agreement and the power of attorney verified, vetted
If I might just interrupt you, could you just explain to the viewers what a joint development agreement is?
See, a joint development agreement is a contract between the builder and the landowner. Instead of the builder purchasing the land by paying money to the landowner, the landowner gets in exchange a bit of constructed area. So instead of money, he gets a portion of constructed area. That is called a joint development agreement. So once the builder puts up the units, some portion of it will be automatically belong to the share of the owner, and he will be entitled to sell it. The developer will be entitled to sell his portion. It is normally coupled with a power of attorney given by the landowner to the builder to sell the builder's share of constructed area. And what was the question again?
The question Kapoor asked was, what specifications should he look into before getting into the agreement with the local builder?
Yeah. So once the agreement draft is generated and sent to the landowner, he should be really careful to get it vetted by a competent lawyer, because it will have a lot of clauses which are detrimental to him. So he should first of all make sure that the delivery will be on time, and that there will be a huge penalty if the delivery is not given on time. He should make sure sharing agreement is proportionate to the advantages and disadvantages of the building. uh, then he should make sure his share of the property is not going to be mortgaged by the builder. It should be free of mortgage. Then he should make sure where the originals are to be kept, with whom. Should it be in escrow, or what is it going to be? And then there are some clauses which says that the builder will give you your portion of the flat, but you know, so many ways of saying that you'll have to pay for the lifts, you have to pay for the electricity and water deposits, you'll have to pay the VAT and taxes. And VAT and service taxes are, you can calculate it in two or three different ways. And I've known a case where the landowner had to simply sell at least half of his portion of the of allotted flats uh, just to meet the demands of the builder in terms of all these extra charges. It came up to many crores. So it is, the other thing is, joint development agreements are considered by the income tax department to be sales, and the landowner is being asked to pay capital gains tax immediately on signing the joint development agreement. So he hasn't got any money with him. He's just got a refundable security deposit, and on the very day of signing the joint development agreement, if he has to shell capital gains when the property is not ready, when he hasn't really sold the flat, then it becomes a very, very, very taxing proposition for him. So I would really suggest to this person to also take a very competent chartered accountant on his.
Right. So, and I was thinking, if this whatever property is being built on this piece of land of Mr. Kapoor, if it's a commercial property, shouldn't profit also be mentioned in the joint development agreement? Because what portion of profit would be taken by the builders and the party, Mr. Varun Kapoor?
Yeah. So sometimes the joint development agreements are made on basis of revenue sharing, which
Hmm.
means that no physical share of the property is given. But whenever the property is sold, some portion of the money gets allotted to the landowner. He take it, and some portion will get allotted to the builder. That is another model of joint development agreement. Instead of physical property, they take revenue sharing. That model is also okay.
Right, right, okay. So moving on to the next question. This is from KK Khanna. The question is, please advise if law allows investing in more than one property for proceeds of sale of a property. If so, what is the time frame available to invest in such purchases? Are there any mandatory requirements or restrictions that ought to be followed?
Okay, I'll answer this very generally. Basically, it's a question to a chartered accountant, but
Mhm.
I think very general guidelines. So the thing is, I think you should purchase one other residential property only. and you are given 3 years time to construct it and 2 years time to purchase it from the date you sell the property. Uh, this is a whole new complicated chartered accountant question, because you also have to take into account indexation of the property and what exactly is capital gains. So I would suggest that he really poses this to a chartered accountant.
Right. Um, the next question is, can the developer impose a condition of 10% payment before revealing or showing documents related to registration, title, ownership, and approvals while booking a flat?
Yeah, this is a very good question again. Now, builders are charging anywhere up to from 50,000 to 1 lakh to 2 lakhs just to share the documents with you. Uh, I think we need to wait for the real estate regulation bill to come to curb this practice, because it makes no sense to pay so much and then get the property just to get the property documents, and if you're not satisfied with it, of course you'll have to go back and get your money back, which they orally promise that they will give. But in one instance I've seen a booking form where they've asked you to sign, which says that if you do not buy the property for any reason whatsoever, they were going to deduct 1.5 lakhs. So he had already signed it and it had become a contract, which uh, when the title was not so clear, he had to uh, lose 1.5 lakhs. So first of all, the practice itself is not so ethical, and secondly, to deduct money when you are not satisfied with the title is completely unacceptable.
Right. Um, the next question is from Dinesh. He's from New Delhi. He says, I want to know how to ensure clarity of title of a builder floor. I do not want to get cheated in these property deals. Can a property be resold twice or even thrice without the knowledge of the sub-registrar?
See, when he says, first of all, yeah, again and again, I would advise somebody to take the property to a very good property lawyer.
Yeah.
Second, it cannot be sold again and again and again. There are two ways to do it. One is something called an agreement. An agreement of sale coupled with possession will never reach the sub-registrar's office, but
Right.
another person will be in possession of the property and the entire money would have been paid. So
Mhm.
people loosely understand it as a sale, but it is not a completed sale. So that way, of course, there can be transactions like that. And one or two cases, there are instances where the same property has been sold again and again. Now, this will not happen if you look at the encumbrance certificate. Encumbrance certificate will show you the last known registered transaction in a property, a registered sale deed. So, if the encumbrance certificate is not checked, which is a very fundamental and primary uh, foundation of due diligence, then of course these resales can be overlooked and you can be a victim of that.
Right, right. But we are really short of time, so I'll just take the question. This is from Ragini. He asks, is it important to obtain an NOC from society before selling the property? What if the NOC is denied? Is there a solution?
Yeah, see, now again, as I told you, all property laws have very localized state laws. Now, in Maharashtra and especially in Bombay, the entire land is held by a cooperative society, and therefore the title to the land comes only from their registrar. Okay, and therefore an NOC from the society is very important in that case. There, the title itself goes to the society. In other states like Bangalore, the NOC is available for the reason for the reason that there are no notary in the city. So without NOC, they are very restricted. There are various restrictions. First, within the city, you have to be legally blind, and if you are legally blind, if you are able to underwrite property, you have to be able to start your business. Second, there has to be mention in writing a word DNA after your title, and it is basically approved by the cooperative society owner of the land who owns the title. In such cases, an NOC is absolutely necessary to obtain the property title. So it depends. The severity of the emergency denial thereof varies from state to state.
Right. Vatsala, any parting thoughts that you would like to share with the consumers, any piece of advice that you would like to give to our consumers so that they are away from as many legal hassles as possible?
Yeah, always don't go by your developer's title opinion or the bank lawyer's title opinion, or your friend's opinion that this he has checked the title and the property is good. Uh, I don't think you should shortchange yourself for a little money. I think you should take the trouble and get the property papers verified. You can even do it two times. Take a second opinion and then proceed with it. Don't take shortcuts.
Right.
And also inspect the original documents of title. Uh, that is very important to ensure the deed is proper.
Right. Thank you, Vatsala. Pushpa, would you like to say something?
Thank you so much, Namrita. I'm really thankful to our guest speaker for participating in this Hangout session. It was indeed a great session. I would also like to thank all our participants for their support in making this Hangout a great success. Thank you all.
Thank you.